watching UNO with Dr. Ambrish Saxena.
Hello students, today is Thursday 17th of October 2019. Today we will try to unfold a story related to development. It is about the Land Acquisition Law in India. The first Land Acquisition Act was passed by British Parliament for India in the year 1894. This law remained in force even after independence. In 2013, another law was passed by Indian Parliament. This is right to fair compensation and transparency in land acquisition, rehabilitation and resettlement. It came into implementation in January 2014, but the same year elections took place. A new government came to power, that is NDA government led by Narendra Modi. This government, the first task that it took up was to bring an amendment in the law which was implemented the same year, because NDA government was of the opinion that the law was too much to the side of the farmers, which according to it was detrimental to development and growth. The amended law was brought to Parliament in February 2015. It was passed by Lok Sabha, but it could not sail through Rajya Sabha. So, in May 2015, the government decided to bring an ordinance. This ordinance was repeated 3 times because the government failed to get the law passed from Parliament. Finally, the government decided to drop the amendment, and then the original law which was passed in 2013, that remained in effect. Now, what is the problem with this law? Now, as far as the implementation is concerned, a case reached in the Supreme Court with regard to compensation in the year 2014. The Supreme Court ruled that if the compensation has been paid to the farmers and farmers are not ready to accept that compensation, that what should be done? The argument of the government is that in that case the compensation can be deposited with the government treasury. But the Supreme Court said that this is not enough and the compensation has to be deposited in the court. Another case in another bench, the 3-judge bench of the Supreme Court, came in 2018. In this case, the Supreme Court ruled that the compensation deposited in the treasury is fine enough and there is no need to deposit the same in the court. And this 3-judge bench also said that the earlier bench order will be superseded by its order and it will not be a legal precedence. Another case reached the Supreme Court in 2018 only, and the 3-judge bench ruled that the earlier judgment given by the 3-judge bench of the Supreme Court in 2018 was not proper because it had no right to supersede the earlier judgment which was also made by a 3-judge bench. So, this bench ruled that a constitutional bench should be set up by the Chief Justice of India to look into this matter and decide this case for all time to come, and that should be treated as the final precedence. This 5-judge bench is headed by Justice Arun Mishra. Interestingly, Justice Arun Mishra was also in the bench which in 2018 only overruled the earlier judgments. So, heading of this bench by Justice Arun Mishra is being opposed by farmers' unions, and they have written to the Chief Justice that he should be recused from hearing this case and another judge should be appointed. But Chief Justice of India has not conceded to this request. So, this 5-judge bench has started its hearing on Tuesday. Justice Arun Mishra has also said that he is not going to recuse himself because there is no reason for doing that. So, now let us see what kind of judgment this constitutional bench is going to make as far as the compensation to farmers farmers whose land is being acquired is concerned. Another story is also coming from the Supreme Court. As we all know that only yesterday the Supreme Court has winded up its hearing in Ram Janambhoomi Babri Masjid case. The hearing happened for 40 days continuously. Now, if we look at the other case which witnessed such a long hearing in 2018 only, in the Aadhaar case, the hearing continued for 38 days, and in the Keshavanand Bharti case, the hearing continued for 68 days. If we refer to Keshavanand Bharti case, which is considered the most landmark case in the judicial history of India. This case was handled by a 13-judge bench, and the judgment was a split judgment. It was 7/6. Whereas if we look into the Aadhaar case, that was heard by a 5-judge constitutional bench, and this was also a split. It was a 4-1 judgment. Now, looking into Keshavanand Bharti case, it was important because it interpreted for the first time and for all time to come what is judicial review, what are the powers of parliament as far as amendment in the constitution is concerned, and in what circumstances Supreme Court can review any amendment that would have been taken by parliament. And Supreme Court was of the view in its judgment that parliament has enough powers to amend the constitution, but it cannot take up an amendment which is not in tandem with the basic structure of the constitution. And how basic structure of the constitution has been defined? It is about basic principles and values. So, this basic structure doctrine was propounded this way. Now, as far as the Aadhaar case is concerned, here also the Aadhaar was challenged in the Supreme Court as unconstitutional. In this case, the Supreme Court struck down section 57 of Aadhaar. Aadhaar means that's a unique identification number, or the act that was brought by parliament in that case, which means that Aadhaar number will not be applicable on corporates, on private entities. The most important thing that has happened in Ram Janambhoomi Babri Masjid case, the Supreme Court conducted hearing on a day-to-day basis. What is meant by day-to-day basis? If we look this factor in Keshavanand Bharti case or the Aadhaar case, that also happened on a day-to-day basis, but that day-to-day meant 3 days in a week. In this case, day-to-day means 5 days in a week. Though there is one thing which is different in Ram Janambhoomi case, it is a case that has come to the Supreme Court through appeal against the judgment of the High Court. The Lucknow bench of Allahabad High Court decided this case in 2010 and divided the disputed land into 3 concerned parties, that is Ram Lala Virajman, Nirmohi Akhada and Muslim Waqf Board, and each one got 2.7 acre of land. Now, whether the Supreme Court is upholding that ruling or adding something new, whether it will be a split judgment, whether it will resolve the case, it will be decided within a month. And this again is an important factor, because in all the earlier cases, whether it's the Keshavanand Bharti case or the Aadhaar case, the Supreme Court took 3 to 4 months time to write the judgment after completing the hearing. What could be the way out to this kind of legal and judicial issues? Only the policy makers and the experts can tell, and that is all in today's